Good morning. It is Monday, June 29th. I'm Lauren Prisball.
And I'm Tim Ryan. Same-sex couples who were turned away on Friday in Denton County should be able to get their marriage licenses today.
The county clerk refused to issue them until she got a ruling from the Attorney General. Dan Godwin live in Denton with more. Dan?
And Lauren, as Tim mentioned, we should see those marriage licenses issued here today. The Texas Attorney General, though, has issued a blistering attack on the Supreme Court decision involving same-sex marriage. Attorney General Ken Paxton calls it a lawless decision and says the High Court has manufactured a right that does not exist in the Constitution. And Paxton goes on to say that state and county workers can refuse to issue same-sex marriage licenses, and judges and justices of the peace can decline to conduct gay marriage ceremonies if they have religious objections. Paxton also says any employee who chooses to exercise their religious freedom in this way could face litigation or a fine, but that there will be lawyers ready to represent them at no charge. Meanwhile, the morning news reports the Denton County Clerk now says she will issue licenses to all couples who request them. On Friday, Julie Luke said she was waiting for guidance from the state attorney general. Luke says although her religious beliefs tell her marriage is between one man and one woman, she must, as a public official, uphold the law. On Friday, some couples who were told they could not get a license here in Denton County held wedding ceremonies on the courthouse steps. Reporting live in Denton, Dan Godwin on Good Day.
Well, to help us put things into perspective, we hope, Chad Ruback, who is an appellate lawyer. The ruling from the U.S. Supreme Court, the majority ruling, it was a divided ruling. It was 5-4, some bitter dissent. But 5-4, and the majority ruling is what stands. It was pretty unambiguous about what states and counties have to do.
It could not have possibly been clear. Justice Kennedy, in his majority opinion, said that states are required to treat same-sex couples the exact same as heterosexual couples when it comes to issuing marriage licenses.
Which means that they must, not may, must issue licenses. Is that the way you read it?
If a county clerk is going to issue a marriage license for a heterosexual couple, then that county clerk must grant the same accommodation to a homosexual couple.
Some people may say, well, you know, if that clerk has religious objections, then the couple should just go somewhere else to get the license.
That's not what the Supreme Court opinion says. The Supreme Court opinion says that states, which would include their county subdivisions, are required to grant the same accommodations to homosexual couples as heterosexual couples. This would just be like a county clerk saying, well, I don't believe there should be mixed race marriages. So if there's an African-American man and a Caucasian woman, I have an objection to issuing a marriage license and I'm just not going to do it. That can't be done.
There was a judge in Dallas County who said, until everyone can get married, I'm not going to do any marriages. On the flip side, could a judge somewhere who has religious objections say, I'm just not going to do any marriages?
Absolutely. The reason for that is that a judge is not required to marry people as part of his or her job description. On the other hand, a county clerk is required to issue marriage licenses as a part of his or her job description.
Let's go outside the government realm and let's go to, for example, the baker who may have religious objections to same-sex marriage, the photographer, the wedding hall, the reception hall owner who may have objections. Can that person say, I just don't agree with what you're asking me to do, therefore I'm not going to bake that cake, I'm not going to rent you the hall, I'm not going to take the pictures?
Absolutely. The Supreme Court decision only applies to governmental entities. A county clerk has to follow. A baker who owns a bakery, a photographer who owns a photography studio, on the other hand, is not a governmental actor and can decide, listen, I want to discriminate.
And quickly, the Attorney General of the state of Texas says if any county clerk has religious objections, my lawyers will stand up and defend you.
Well, Attorney General Paxton doesn't seem to understand that the U.S. Supreme Court is the sole arbiter of what the Constitution means. Not the Texas Attorney General, not even the U.S. Attorney General.
This issue is settled.
It's done.
Okay, thanks very much.
Thanks for having me.
All right, let's go to Evan right now. We're going to heat things up in the weather.